Senator Simons.
Thank you very much, Mr. Speaker. I had not intended to speak, but I felt, as I was listening, that there was a point that has to be made here, and that has to do with the premise of things that are ex post facto. I'm going to tell you, I'm going to say on the record, my daughter was recently accepted to Oxford University to do her master's degree, and she's going to be looking at ancient Roman law, which is why ancient Roman law is perhaps top of mind for me. It is a principle dating back more than 2,000 years in the Western legal tradition that we do not change the rules on people ex post facto, so that something comes afterwards. That if you're going to, for example, criminally charge someone, the thing you're charging them with has to have been a crime at the time they allegedly committed the offense. You can't change the law and then go back in history and retcon things so that you can punish them for something that wasn't a crime at the time it was permitted. This is known in law as retrograde temporal application. And we don't have a time machine that allows us to punish people for things that they couldn't have foreseen. And this is, I think, what Senator McPhedran's amendment points to. I understand Senator Dean's point that you don't want people suddenly racing to file claims as this law is passed, although presumably if they had been thinking about this, they would have done that months and months ago, since these changes have been in the offing for some time. It seems to me, though, that it is not unreasonable to carve out an exception for people who made good faith applications months and months ago under the existing rules. Ex post facto is a fancy Latin term. In English, we would say pull the rug right out from under them. To change the rules in the middle of the game is fundamentally unfair. It's why our Canadian Charter of Rights and Freedoms enshrines in Section 11 protection against being charged for something, and I grant you a criminal, we're talking about criminality here, but it's protected in the Charter that you can't be charged criminally for something that wasn't a crime at the time you committed it. It's also in Section 15 of the United Nations International Covenant on Civil and Political Rights. It is understood as a fundamental underpinning of our legal system dating back to the time of the Caesars that it is unfair to change the rules on someone in the middle of legal proceedings. And that is what we are talking about. I think the other small genius of Senator McPhedran's amendment is that it doesn't affect the application of the bill going forward. It only affects a very small number of people who have been caught in this time warp. And I think in honor of a fundamental principle of justice, it is manifestly unfair, as any child in the schoolyard would know, to change the rules halfway through the game. And that is why I will be supporting Senator McPhedran's amendment.
Are senators ready for the question? In amendment, it was moved by the Honourable Senator McPhedran, seconded by the Honourable Senator Arnold, that Bill C-12, as amended, suffit, dispense. Is it your pleasure, Honourable Senators, to adopt the motion in amendment? All those in favor of the motion, please say yea. Yay. All those opposed to the motion, please say nay. Nay. In my opinion, the nays have it. I see two senators rising. Do we have an agreement on the length of the bell? Now? Is leave granted? Yes. Leave is granted.